Senator Leahy, and now Senator Graham.
Thank you, Judge. Again, congratulations. I want to talk to you a little bit about family and faith because in your opening statement and the people who introduced you to the committee, there was very glowing praise of you as a person, a good friend. You have a wonderful family. You should be proud, and your faith matters to you. What faith are you, by the way?
Senator, I am Protestant.
Mm-hmm. Okay.
Non-denominational.
Okay. Could you fairly judge a Catholic?
Senator, I have a record of
I think
fairly
the answer would be yes.
judging everyone.
I believe you can. I'm just asking this question because how important is your faith to you?
Senator, personally, my faith is very important. But as you know, there's no religious test in the Constitution under Article 6, and
there will be none with me.
And it's very important to set aside one's personal views about things in the role of a judge.
I couldn't agree with you more, and I believe you can. So on a scale of 1 to 10, how faithful would you say you are in terms of religion? You know, I go to church probably 3 times a year, so that speaks poorly of me. Or do you attend church regularly?
Well, Senator, I am reluctant to talk about my faith in this way just because I want to be mindful of the need for the public to have confidence in my ability to separate out my personal views.
Well, how would you feel if a senator up here said, your faith, a dogma lives loudly within you, and that's of concern? How would you feel if somebody up here on our side said, you know, you attend church too much for me, or your faith is a little bit different to me, and they would suggest that it would affect your decision? Would you find that offensive?
Senator,
I would if I were you. I found it offensive when they said it about Judge Barrett. The reason I ask these questions is I have no doubt that your faith is important to you, and I have zero doubt that you can adjudicate people's cases fairly if they're an atheist. If I had any doubt, I would say so. But the only reason I mention this, Judge, you're reluctant to talk about it because it's uncomfortable. Just imagine what would happen if people on late-night television called you an effing nut, speaking in tongues because you practiced the Catholic faith in a way they couldn't relate to or found uncomfortable. So, Judge, you should be proud of your faith. I am convinced that whatever faith you have and how often you go to church, it will not affect your ability to be fair. And I just hope going in the future that we all can accept that, and that Judge Barrett, I thought, was treated very, very poorly. So I just wanted to get that out. Let's talk about family. Do you know Janice Rogers Brown?
yes, I do know her.
Okay, how do you know her?
She was a judge on the court that I now serve. We didn't overlap, and I'm struggling to remember whether I ever met her, but she was a judge on the circuit court.
Right, and you were a district court judge, is that right?
I was, but I don't know whether she had
I think you were.
Retired
Are they in the
time.
same building?
They are in the same building.
Okay.
They are.
So you really don't know her?
I know of her, yes.
Okay. What do you know of her? What's her reputation?
I know that she's a very well-respected judge on my circuit.
Okay. And in terms of family, she was the daughter and granddaughter of sharecroppers. She was raised in Alabama under Jim Crow. Despite this adversity, she put herself through law school as a single working mother. That's pretty impressive, isn't it?
Yes, Senator.
Your background is very impressive. You seem to have a great family. If family mattered, we would not have done to her what was done to her here in the United States Senate. Do you realize that she was filibustered for 2 years when she was appointed to the D.C. Circuit?
I didn't know that.
Did you know that Joe Biden actively filibustered Janice Rogers Brown?
I did not know that.
Did you know that he told Face the Nation, if Bush nominates her for the Supreme Court, I can assure you that would be a very, very, very difficult fight, and she probably would be filibustered. Is that news to you, too?
Yes.
Okay. Now that you know that, how do you feel about it?
Senator, I can't speak to something that I just learned 2 seconds ago in your
Okay, fair enough.
conversation with me.
Fair enough. You're in the Black Law School Society, right? At
The
Harvard?
Black Law Students Association.
Okay, Black Law Student Association.
Yes.
You're a member at Harvard.
Yes.
And in sometime, the Mr. Jeffries thing, do you remember that whole dust-up? He got...
Only in preparation for this, and I think I was in college at the time. It was my senior year of college.
Okay, so you weren't actually in the group when he was invited to speak?
I don't know which group invited him to speak. I was a black student at Harvard, both in the Harvard Undergraduate Black Students Association and the Harvard Law School Black
Right.
Students Association.
Do you remember going to a speech given by Mr. Jeffries? I think he's the uncle of Akeem Jeffries.
I did not go to a speech
Okay.
given by Mr. Jeffries.
Are you now familiar with the press reports about what Mr. Jeffries' views are?
Just in preparation for this.
Okay, and you do you associate yourself with those views?
I do not, Senator.
As a matter of fact, he's been called by many as very anti-Semitic. He called Jews skunk who stink up the place. You don't agree with that, do you?
I do not, Senator.
And it would be wrong for me or anybody else to hold his statement against you because he spoke at some group you're a member of, right?
Senator, I don't have, yes, it
It would be. Yeah, that's right. That's the right answer. I thought that was the right answer with Judge Alito. When they made a big deal about some group he was in that had views that he didn't agree with and tried to call him basically a racist, and found out that Senator Kennedy, God rest his soul, who beat the crap out of the guy for being part of some supper club that was actually in some organization called the OWL that didn't admit women. So I guess the reason I'm bringing all this up is it gives me a chance to remind this committee in America there are two standards going on here. If you're an African-American conservative woman, you're fair game to have your life turned upside down, to be filibustered no matter how qualified you are. And if you express your faith as a conservative, all of a sudden you're an effing nut. And we're tired of it. And it's not going to happen to you. But it just appalls me that we can have such a system in America, that if a conservative woman wants to stand out and say, I love my family just as much as you love yours, and my faith means just as much to me as it does you, that all of a sudden there comes some kind of weirdo. And a guy like Justice Alito, who's in the same type situation you're in, being in a group, doesn't agree with everything they do or what people may say at a meeting he didn't go to, all of a sudden they own it. You know, this stuff needs to stop. Our people deserve better respect, and I hope when this is over, people will say you were at least well treated, even if we don't agree with you. So now let's talk about Gitmo. Being a public defender, did you consider that rewarding?
Senator, yes, I did, because public service is very important to me. It is an important family value. It is something that now I've dedicated my career to.
Yes. And do you think it's important to the system that everybody be represented?
Absolutely. It's a core constitutional value.
You'll get no complaint from me. That was my job in the Air Force. I was a area defense counsel. I represented anybody that came in the door, whether I liked them or not. I did my best. Is that what you did?
Yes, sir.
Okay, good. Now, so the American people deserve a system where everybody's represented, where you like them or not, and anybody that takes up that cause, no problem with me. You're just doing your job, and I think you make our country stronger. But there's the other side of the story that never gets mentioned when I talk about Gitmo. The American people deserve a system that can keep terrorists off the battlefield. They deserve a system that understands the difference between being at war and a crime. Do you consider 9/11, you said, a terrible, tragic event? Would you consider it an act of war?
Yes, Senator.
Okay, I would too. I think it was an act of war by Al-Qaeda and associated groups against the people of the United States. So as you rightfully are proud of your service as a public defender, and you represented Gitmo detainees, which is part of our system, I want you to understand, and the nation to understand, what's been happening at Gitmo. What's the recidivism rate at Gitmo?
Senator, I'm not aware.
It's 31%. How does that strike you? Is that high, low, about right?
I don't know how it strikes me overall.
You know how it strikes me? It strikes me as terrible.
Yes, that's what I was going to say.
Okay, good. We found common ground. Of the 229 detainees released from Gitmo, of 729 released, 229 have gone back to the fight. Here's some of the notables. Former Gitmo detainee Zakir was named the interim defense minister of Afghanistan. I don't know exactly what his job is today, but during the transition, they made him the defense minister and he was in Gitmo. Of the 5 men we released from Gitmo as part of the prisoner swap for Sergeant Bergdale, here's where they're at. Mohammed Fazal was appointed Deputy Minister of Defense. Noor was appointed Acting Minister of Borders and Tribal Affairs. Waziki was appointed as Acting Intelligence Director. Kerr, again, Acting Minister of Information, Culture, Defense. Omar was appointed as the new governor of the southeastern province of Khost. These were 5 people that we had in our control that are now helping the Taliban run the country. Would you say that our system in terms of releasing people needs to be re-looked at?
Senator, what I'd say is that that's not a job for the courts in this way. That
as an American, does that bother you?
Well, obviously, Senator, any repeated criminal behavior or repeated attacks, acts of war, bother me as an American.
Well, it bothers me. While I will not hold it against you, nor should I, the fact that you represent Gitmo detainees, I think it's time to look at this system new, folks. When 31% of the people are going back to fight to kill Americans and now running the Taliban government, we have gone wrong somewhere. Are we still at war?
So the AUMF, the authorization for military force, is still in effect. Congress has authorized the use of force against people in this way.
But do you personally believe that Al-Qaeda, ISIS-type groups are still at war with us?
I think, yes. I mean, I think
So we're still in a state of war with certain elements of radical Islam to this very day?
I believe that's documented, yes.
Okay. Now, what's the process to determine whether one's an enemy combatant under our law?
Well, I believe that the executive branch makes an assessment of whether or not someone is taking up arms against the United States somewhere in the world related to all of this.
Okay, so it's an executive branch function to determine whether or not this person qualifies as an enemy combatant.
Well, I believe that they make a
Under current law.
Under current law, I believe that determination is made by the executive branch, and the person is detained, and then the question becomes whether they are able to bring some sort of legal challenge to that
They have a habeas
determination.
right.
Yes.
Okay, so the law is that the executive branch determines if you're an enemy combatant, and under our law, you can appeal that decision to a federal court through habeas. Is that correct?
I believe that's correct.
Okay. Is it your view that we can hold enemy combatants as long as they're a threat to the United States?
I believe that's what the Supreme Court has determined.
Okay. Did you argue that that should not be the case before in an amicus brief?
I'm trying to think. I had 2 amicus briefs that I worked on, or 3 technically, but 2 different cases.
Well, we'll have another visit tomorrow. So
Yes.
Go back and check.
Yes.
I'm pretty sure that in your brief you argued that the executive branch should not have the ability to hold an enemy combatant indefinitely. You need to try them through some process or release them.
Yes, Senator. As you were talking, my clients, the Cato Institute, the Rutherford Institute, and the Constitution Project, made that argument and asked me to draft their brief.
Yes. Well, do you agree with that argument?
Senator, my responsibility was to make my clients' arguments, and as a nominee to the Supreme Court, that's the kind of issue. The Supreme Court did not address that issue. They, in fact, the case became moot.
Did you organize an effort to get 20 judges to file a brief to the Supreme Court on this issue?
Not on that issue, no, Senator.
On another issue?
Yes, Senator.
Okay. Did you actively go out and recruit 20 judges to help you file a brief on another issue regarding law of war detention?
Not technically.
What do you mean by that?
What I mean is that I was at Morrison and Forster, which was my law firm, in the Supreme Court and appellate group. One of the partners at Morrison and Forster was a former federal judge who wanted to make this argument and who said, I have former federal judges who are friends of mine who would like to join with me to make this argument. So I worked with her, the partner at my firm, who was a former federal judge, to make...
It was her idea to get former judges to write this,
Yes.
not yours?
Yes.
And you just helped in the implementation of that idea?
So, Senator, as a member of the Supreme Court and appellate group in a law firm, that is the practice.
Right. Now I'm asking
Amicus practice, yes.
It wasn't your idea, it was somebody else?
Yes.
Okay. So now, there are people still held at Gitmo today. Do you understand that?
Yes.
Okay. What system is in place regarding their future?
I am not aware of the system right now. I'm not sure exactly what you mean.
Let me tell you what it is.
Yes.
There's a periodic review process made up of an interagency where they go through the files of these folks and they determine whether or not they still present a threat to the United States or the world at large. And I think it's 6 months, maybe a year. But that goes on at least on an annual basis. And if there's a determination that this person still represents a threat to the United States, they're continued to be confined. That's the way the system works. Are you okay with that?
As a policy matter, Senator, I'm not speaking to my views. That's my understanding is that the periodic review system is an executive branch determination of whether or not they're going to continue to hold people that they...
Does that make sense to you as a way to deal with these detainees?
Senator, I'm not in a position to speak to the policy or the discretion of the executive branch regarding how they're going to handle detainees.
The reason I mention it is because in one of the briefs you argued that the executive branch doesn't have that option. That if you had had your way, the executive branch could not do periodic reviews about the danger the detainee presents to the United States. They would have to make a decision of trying them or releasing them. Is that not accurate?
Respectfully, Senator, it was not my argument. I was filing an amicus brief on behalf of clients, including the Rutherford Institute, the Cato Institute, and the Constitution Project, who...
When you sign on to a brief, does it not become your argument?
It does not, Senator. If
wow.
if you are an attorney and you are representing a client in amicus...
Is that your position when you were in private practice? I mean, you sign on to this brief making this argument, but you say it's not your position. I mean, why would you do that if it's not your position? Why would you take a client that has a position like that? Now, this is voluntary. Nobody's making you do this.
Oh, Senator, I would refer you to the same sorts of statements that Chief Justice Roberts made when he came before the committee, which is that lawyers represent clients.
I get that. I'm not holding the client's views against you. The people you represent at Gitmo, they deserve representation. But this is a amicus brief where you and other people try to persuade the court to change policy. The policy I described is a periodic review. If the court had taken the position argued in the brief that you signed upon, we'd have to release these people or try them, and some of them, the evidence we can't disclose because it's classified. You're putting America in an untenable position. This is not the way you fight a war. If you tried to do this in World War II, they'd run you out of town. We hold enemy combatants as long as they're a threat. There's no magic passage of time that you got to let them go. So my question is very simple. Do you support the idea, did you support then the idea that indefinite detention of an enemy combatant is unlawful?
Respectfully, Senator, when you are an attorney and you have clients who come to you, whether they pay or not, you represent their positions before the court.
I'm sure everybody at Gitmo wants out. No, I got that. This is an amicus brief, and I just don't understand what you're saying, quite frankly. I'm not holding it against you because you represented a legal position I disagree with. I mean, that happens all the time. I'm just trying to understand what made you join this cause. And you say somebody hired you, but did you feel okay in adopting that cause? I mean, when you signed on to the brief, were you not advocating that position to the court?
Senator, as a judge now,
okay,
in order to determine the lawfulness or unlawfulness of any particular issue, I need to receive briefs and information making positions on all sides. And
I got what a judge is all about. Listen, I'm not asking you to decide the case in front of me right here. I'm asking me to explain a position you took as a lawyer regarding the law of war, and I am beyond confused. I know what you said in your brief. Whether I agree with it or not, it's not the point. I just want you to understand that it's important for all of us to know where you were coming from. If that brief had been accepted by the court, it would be impossible for us to fight this war. Because there's some people going to die in jail in Gitmo and never go to trial for a lot of good reasons, because the evidence against them is so sensitive we can't disclose it to the public. That we're not charging them with a crime. What we're doing is saying that you engaged in hostile activities against the United States, that you are an enemy combatant under our law, and you will never be released as long as you're a danger until the war is over or you're no longer a danger. That's the difference between fighting a crime and a war. Did you ever accuse in one of your habeas petitions the government of acting as war criminals for holding the detainees? The holding of the detainees by our government, that we were acting as war criminals?
Senator, I don't remember that accusation, but I will say that...
Do you believe that's true, that America was acting as war criminals in holding these detainees?
Senator, the Supreme Court held that the executive branch has the authority to detain people who are designated as enemy combatants for the duration of the hostilities. And what I was doing in the context of the habeas petitions at this very early stage in the process was making allegations to preserve issues on behalf of my clients. A habeas petition is like a complaint that lawyers make allegations.
You know, I've been a lawyer too, but I don't think it's necessary to call the government a war criminal in pursuing charges against a terrorist. I just think that's too far. I don't know why he chose those words. That's just too far. But we are where we are. So let's talk about the nomination process. Have you ever had any interaction with a group called Demand Justice?
No.
Directly or indirectly?
No.
Have you ever had any interaction with a group called American Prospect?
No.
Do you know anything about Arbella? Is that the right term? Have you ever heard of a group called Arbella?
I've heard of a group that I think is Arabella or something like that.
I think you're right. Not
Yes.
the Arabella. Yeah. Do you know anything about them? Have you had any contact with them?
No.
Okay. In your nomination, did you notice that people from the left were pretty much cheering you on?
A lot of people were cheering me on,
That's
Senator.
true. That's true. Did you know that a lot of people from the left were trying to destroy Michelle Childs? Did you notice that?
Senator, a lot of people were supporting various people for this nomination.
So you're saying you didn't know there was a concerted effort to disqualify Judge Childs from South Carolina because she was a union-busting, unreliable Republican in disguise?
Senator, I'm a sitting judge. I was focused on my cases.
Well, the answer is no, I didn't know that.
No, I didn't know that.
Would it bother you if that happened?
Senator, it is troublesome that people are or were doing things related to
I think
the
that's
nomination.
the best way to say it. People have a right to speak out and pick the person of their choice. But all I can say is that if you miss the fact that there was an organized effort, well, here's President Biden has only a certain amount of political capital for keeping his party united. If he needlessly angers progressives on this SCOTUS pick, that could create all sorts of problems for him down the line. Jeff Hauser, revolving door projects. Let's see. I just got so many quotes. It's difficult to imagine someone with a record like Judge Childs winning votes from criminal justice advocates like Senator Cory Booker, even Dick Durbin. Childs' experience is nothing like the diversity of experience that the Biden administration has championed. Let's see. Picking her, Childs, would demoralize the base, side with corporate America. The fact that Lindsey Graham is vouching for her should give the White House pause. Our revolution, Joseph Gervangi, or whatever his name is, I'm sorry about that, Joseph. He's Bernie Sanders' PAC director. You didn't know that all those people were declaring war on Judge Childs?
Senator, I did not.
Okay. Well, no, I'm not saying you did. You said you didn't know. I'll take it at your word. But I am saying that what is your judicial philosophy?
So I have a methodology that I use in my cases in order to ensure that I am ruling impartially and that...
So your judicial philosophy is to rule impartially?
No, my judicial philosophy is to rule impartially and to rule consistent with the limitations on my authority as a judge. And so my methodology actually helps me to do that in every case.
So you wouldn't say that you're an activist judge?
I would not say that.
Okay. So we'll have 20 minutes more later on, but here's what I would say. That every group that wants to pack the court, that believes this court is a bunch of right-wing nuts that are going to destroy America, that consider the Constitution trash all wanted you picked. And this is all I can say, is the fact that so many of these left-wing radical groups that would destroy the law as we know it declared war on Michelle Childs and supported you is problematic for me. Thank you.
Thank you, Senator Graham. Let me mention a few points here. Congressman Jim Clyburn was a strong supporter of Michelle Childs, and now I believe he is publicly supporting your nomination. And Michelle Childs has been nominated by President Biden to be a circuit judge, and she will be considered by this committee as quickly as possible. On the issue of Guantanamo, there are currently 39 Guantanamo detainees remaining. The annual budget for Guantanamo is $540 million per year, which means each of these detainees is being held at the expense of $12 or $13 million per year. If they would be incarcerated at Florence, Colorado, the Supermax prison, federal prison, the amount would be dramatically less. Since 9/11, nearly 1,000 convicted in the United States on questioning will resume. Senator Graham.
Thank you, Mr. Chairman. Good morning, Judge. Thank you.
Sorry. Good morning, Senator.
I want to comment on the last exchange. And Judge, this is not of your making, so it's really not about you, but Representative Green, who's a fine man, came up and said he thought the exchange between you and Senator Leahy at the end about the arc of time and how far we've come as a nation was powerful. I agree. It was powerful. And I guess here's my point I'm trying to make to the American people, to my Democratic colleagues. I wish you had that same attitude when an African-American conservative is appointed to high office in the judiciary. So what happened with Janice Rogers Brown? In 2003, she was an African-American nominee for the D.C. District Court, 54 years old, a little bit older than you, but pretty close. She was a daughter and granddaughter of sharecroppers, a childhood in Alabama under Jim Crow. She was a single mother, a member of the California Supreme Court. Instead of celebrating how far we've come, my Democratic colleagues filibustered her ascension to the D.C. Circuit Court. Because it's well known on our side that we were very much considering her to be the first African-American woman on the Supreme Court. So rather than this wonderful exchange, which was wonderful, Representative Green, where were you and others when there was a wholesale assault on her nomination? Nowhere to be found. The filibuster was used for 2 years to stop her nomination, and we eventually did the Gang of 14, of which I was a part, so that she could make it through after 2 years of waiting. This is what the current president said when he was in the Senate, Joe Biden, asking about her, Janice Rogers Brown, being on the Supreme Court. I can assure you that would be a very, very, very difficult fight, and she probably would be filibustered. That's what he said about an African-American conservative nominee by President Bush who had served 5 years on the California Supreme Court. We're not going to live in America like that any longer. To my Democratic colleagues, if you're a person of color, a woman supported by liberals, it's pretty easy sailing. But if you're Miguel Estrada, Janice Rogers Brown, Amy Coney Barrett, on and on and on, your life gets turned upside down. You had nothing to do with that. I just make this observation that when you come up to me and talk about how moving the exchange was, I agree. And I just want to remind you there was somebody else of color, a woman of color, that was picked for the D.C. Circuit, one of the highest courts in the land, that did not meet the same fate. And those days should be over. Do you believe illegal immigrants should be allowed to vote, Judge Jackson?
Thank you, Senator. Under our laws, you have to be a citizen of the United States in order to vote.
So the answer would be no.
It's not consistent with our laws, so the answer is no.
Okay, why do they do that in New York?
Senator, I'm not aware of the
Okay,
circumstances.
all
that
right,
you're-
well, that's a good answer. The answer is no. Can an unborn child feel pain at 20 weeks in the birthing process?
Senator, I don't know.
Are you aware of the fact that anesthesia is provided to the unborn child at that time period if there's an operation to save the baby's life because they can in fact feel pain? Are you aware of that?
I am not aware of that.
Well, that may come before you one day, so just keep an open mind. That's the only thing I ask you to do. You said just a bit ago that you apply the law and the facts and call them as you see them. Is that right?
That is correct, Senator.
Okay, and you look at the statute as the way it's written, and you try to apply it in its plain meaning. Is that correct?
That is correct, Senator.
Have you heard of a case called Make the Road versus McAleen?
Make the Road New York? Yes.
Yeah, okay. Make the Road in New York, who are they?
Make the Road New York is a nonprofit that represents various individuals in the sort of immigration law
Right.
field.
They're a nonprofit advocacy group for immigration issues. Did you know they received large donations from the Arabella Network and from George Soros's Open Society Foundation Network?
No.
Okay, well, they did. Now, in that case, what was the issue?
The issue in that case was a challenge to a change in administration policy concerning expedited removal, which is a policy that Congress enacted in order to expedite certain removals in the immigration system. Ordinarily, before expedited removal,
Asylum cases do not fall in this category, right?
well,
Trust me on that, because the statute says it doesn't.
if a person who could otherwise be subject to expedited removal makes and has a credible fear of torture in their country, they can be
And can they make that claim?
determined. They
Right.
can be determined
Right.
to qualify for regular removal rather than
Right.
expedited removal.
So expedited removal is a creature of Congress, folks. And if you've been here 2 years or less, the statute, the statute, I'm sorry, the statute. The statute would allow the administration in office to have expedited removal, avoiding a lot of the hurdles that would exist otherwise for people here 2 years or less. So in the Obama, even Bush years, they did not look at it in terms of applying it to everybody. Some people coming by air got expedited removal, others didn't. The Trump administration decided to use the authority given to it by Congress to remove all eligible cases 2 years or less under the expedited removal statute. Is that a fair summary?
Well, Senator, I would say it differently.
Well, say it differently.
All right. The statute that you've put up indicates that Congress is giving the department, it says the Attorney General, but now it's the department,
Right.
the ability to determine what category of aliens.
If you've 2 years or less.
Yeah, but importantly, the authority was, it was not Congress saying 2 years or less. What Congress said is you, agency, have the authority to determine what category of persons between who have been here between 0 and 24 months,
Which is
should
2
be.
years, yeah.
No, but what Forgive me,
So-
Senator. What I'm trying to explain is that the authority given to the agency was to determine what
They
length of
had
time.
discretion to make that
What
decision.
length of time? It was not the authority to deport everyone who's been here for 24 months. It was the authority to determine what length of time a person has to be here in order to be subjected to expedited removal.
Here's what the statute said. The Attorney General, which is actually the DHS Secretary, may apply clauses 1 and 2 of this subparagraph to any and all aliens described in subclass 2 as designated by the Attorney General, actually DHS. Such designation shall be in the sole and unreviewable discretion of the Attorney General and may be modified at any time. Now, I've been in this business for quite a while. What the Trump administration did was to use the discretion given to it by statute in a way different than prior administrations. This advocacy group, the Arabella-supported advocacy group, tried to strike it down. You rule for them. Here's what the D.C. Circuit Court said about your ruling. There could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expanded removal within statutory bounds to the Secretary's independent judgment. The forceful phrase, sole and unreviewable discretion, by its exceptional terms. Such designation shall be in the sole and unreviewable discretion of the Attorney General and may be modified at any time. To those of us in the law writing business, I don't know how you could tell a judge more clearly that the administration, the agency in question, has discretion to do certain things within the statute. So this is an example to me, and you may not agree, where the plain language of the statute was completely wiped out by you. You reached a conclusion because you disagree with the Trump administration, and the D.C. Circuit Court of Appeals said, as I've quoted just a minute ago, there could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expedited removal within the statutory bounds to the Secretary's independent judgment. That, to me, is Exhibit A of activism. Let's go back to the child pornography cases.
Senator, would you allow me to?
Yes, please.
Thank you. The statute and the circumstances that you reference are accurate insofar as that is what the statute says. It's not all of it. It doesn't describe the designation process that I was trying to articulate. And it doesn't address the fact that Congress has another statute that is presumptively applied in agency cases to tell agencies how to exercise discretion. There's also D.C. Circuit case law that says that in addition to having that procedural statute be presumptive, even very clear designations of authority to an agency may still be subject to Congress's other directions regarding how to exercise the discretion.
That argument fell on deaf ears.
Understood. That's our appellate process.
I've got other things I want to talk about. You've given an explanation, but it didn't work. The D.C. Circuit Court said there could hardly be a more definitive expression of congressional intent. This is good as it gets. There's no way to write a statute saying discretion lies in an agency. It's sole. It's non-reviewable. So you're not convincing me that
With
this
respect,
was anything
Senator,
other than activism, and we can talk about it all day long, but I agree with the D.C. Court. This, to me, is an example, Exhibit A, of a judge ignoring limitations placed in the law by Congress to get a result they wanted. Child pornography. I have no doubt that you find child pornography disgusting as the rest of America. You're a mother. You seem to be a very nice person. Are you aware of how many images are out there on the internet involving children and sexually compromising situations?
Senator, I'm not aware of the numbers, but I've seen the images in my
And they are disgusting,
role
right? Well, let me
as
tell you
a
the
judge.
numbers. In 2021, the National Center for Missing and Exploited Children Cyber Tip Line received 29.3 million reports of apparent child sexual exploitation containing 85 million images, videos, and other files. That's in 2021. It's up. In 2019, it was less. So there's an epidemic of this on the internet. That if you go out on the internet, there are millions of pictures of kids being abused. When it comes to sentencing child pornography possession cases, do you routinely discount the fact that a computer was used?
Thank you, Senator, for allowing me to address this concern. The guidelines related to child pornography were drafted at a time in which a computer was not used for the majority, if not almost all, of these kinds of horrible crimes. The guidelines have enhancements in them.
In two areas that you said you disagree. What are those two areas?
At the time that the guidelines were drafted, it was an aggravating factor, a substantial aggravating factor, to use a computer in order to distribute and disseminate the images, because the ordinary crime was not committed by computer. So the
Would you now
baseline-
agree with me that computers are sort of the venue of choice for child pornographer people?
Yes, Senator.
Okay, so here's my point. If you believe, as I do, the computer has created a bigger demand, there are more photos out there because of the internet, more websites exposing this garbage, wouldn't you want to deter people from going down that road?
Senator, this crime is among the most difficult.
No, answer my question. Wouldn't you want to deter people from going down the road of using the computer that allows these people to have access to millions of photos because of the technology? I want those people deterred. So if you're listening to my voice today and you're on a computer looking at child pornography and you get caught, I hope your sentence is enhanced, because the computer and the internet is feeding the beast here, that all these images out there are going to be more over time because people use computers. Now, didn't you also say that the number of images should not be considered as a sentence enhancement?
Senator, with respect to the computer, one of the most effective deterrents is one that I imposed in every case and that judges across the country impose in every case, which is substantial supervision. Any of these
wait a minute,
defendants.
Judge. You think it is a bigger deterrent to take somebody who's on a computer looking at sexual images of children in the most disgusting way is to supervise their computer habits versus putting them in jail?
No, Senator, I didn't say versus.
That's exactly what you said. I think the best way to deter people from getting on a computer and viewing thousands and hundreds and over time, maybe millions, the population as a whole, of children being exploited and abused every time somebody clicks on, is to put their ass in jail, not supervise their computer usage.
Senator, I wasn't talking about versus.
You just said you thought it was a deterrent to supervise them. I don't think it's a deterrent. I think the deterrent is putting them in jail.
Senator,
Does
would you let
sentencing
her
have
respond?
a deterrent component?
Senator, would you let her respond?
Yes. Does sentencing have a deterrent component?
Yes, Senator, deterrence is one of the purposes of punishment, and Congress has directed courts to consider various means of achieving deterrence. One of them, as you've said, is incarceration. Another, as I tried to mention, was substantial periods of supervision once the person...
So if I may ask you, in your view, it's more of a deterrent to have somebody substantially supervised in terms of their computer use who's looking at child pornography than it is to put them in jail.
Senator, I'm not saying it's more or
That's
less.
exactly what you're saying.
What I'd like to point out is that if we're going to, let me say it this way. Congress has authorized courts to use a number of different means to achieve the purposes of punishment.
And one of them is an enhanced punishment by using a computer.
The enhancement with respect to using a computer relates to the penalty in terms of incarceration.
And you would choose not to apply that in these cases. You've said that. I'll read you the quote, but you've decided not to apply the use of a computer as an enhancement. You've also said you're not going to hold the number of images that the person has looked at as a sentencing enhancement factor. Is that true?
No, Senator, it's not the number of images that the person has looked at because we don't have that information.
Well,
It is the number of images that they've either received or distributed that are.
we don't know if they looked at them, but you're not going to hold it against them that they received 10,000 images versus 100.
That's not what I've said, Senator.
Well, here's what you said. I've decided to apply my general policy disagreement with respect to those enhancements, at least that is the computers and the number of images. Folks, what she is saying, the reason she's always below the recommendation, I think, is because she doesn't use the enhancements available to her. She takes them off the table. And I think that's a big mistake, Judge. I think that every federal judge out there should make it harder for somebody to go on a computer and view this filth. That if you use that venue, which is the venue of choice for all these child pornography cases, that you use it against them. I think the more you download, like drugs, the more you have, the more you should go to jail. You've made a conscious decision to disregard those two enhancement sentencing factors, and I think that is a wrong way to go in terms of deterrent. To me, putting somebody in jail for using a computer is more of a deterrent than supervising their activity of watching the computer. That's just a difference that we have. I know I'm out of time, and listen, you've lived an incredible life, but here's one thing that won't happen to you as we wrap this up. How would you feel that if I'd had a letter from somebody accusing you of something, a crime or misconduct, for weeks, and I give it to Senator Durbin just before this hearing's over, and not allow you to comment on the accusation? How would you feel about that?
Senator, I'm not sure. I don't understand the context of the question.
Well, did you watch the Kavanaugh hearings?
No, sir.
Are you familiar with what happened in the Kavanaugh hearings?
Generally.
Senator, your time is.
Well, please, Mr. Chairman. So to be honest, it's a minute and 47 seconds. She filibustered every question I had, and she has a right to give an answer, but I'm trying to make a point in 20 minutes. You were here for Kavanaugh. If she's confused about what happened, some people on the other side had an accusation against Judge Kavanaugh that during high school, he sexually assaulted somebody. And the rest is history. That was known to the people on the other side and never revealed during the meetings they had with Judge Kavanaugh. It was literally ambushed. He was ambushed. How would you feel if we did that to you?
Senator, I've appreciated the kindness that each of you has shown me to see me in your offices, to talk with me about my approach.
But my question is, what if during our 15-minute exchange, it was very pleasant, you're a very nice person, you have a lot to be proud of. I would never do that to you. If I had some information that's sketchy at best, that somehow you've done something wrong, I promise you, just from human decency, I would share it with you. I would not disclose it at the last minute of the last day of the hearing, and I've already given it to a newspaper so the whole country can read about it before you ever said a word.
Senator, she's had nothing to do with the cause.
No, but I'm asking her about
you won't even let her finish
how
your
she
response.
may feel about what y'all did.
Could we have order,
Senator, your
Mr.
time
Chairman?
has expired, and I'm going to give her an opportunity to finally complete an answer.
So if I could
Just
address
answer the question.
Senator, I don't have any comment on what procedures took place in this body regarding
What'd you think about the
Justice
Kavanaugh hearing?
Kavanaugh.
you
What
let
I'd
her
like to
finish?
answer is your points about my sentencings in child pornography cases. The point of the guidelines is to assist judges in determining what punishment to provide in cases. And there are horrible cases, but the idea is that between the range of punishment that Congress has prescribed, judges are supposed to be providing proportional punishment based on what a person has done. The sentencing scheme doesn't place everybody at the same level. The point of judging and the guidelines is to look at what has happened in a case, compare defendants to each other in terms of what they've done, and give proportional penalties based.
Mr. Chairman, this is she has said, Mr. Chairman, she does not use sentence enhancements in the area of somebody using a computer for everybody.
Can I explain why, sir?
I'm going to give the witness an opportunity to respond to you, Senator.
Finally.
At
Why?
the time that the guidelines were created for child pornography, this crime was primarily being committed by people who were literally mailing 1, 2, 5, 10, 100 photos at a time.
How's it being committed now?
Would she please
Go
let
ahead.
her complete her answer?
Go ahead.
As a result, the commission determined in the guidelines that it was a substantial aggravating factor if the facts of the case demonstrated that someone had been distributing hundreds of images, because what that meant was over this long, maybe it was a long period of time, they had collected one photo at a time, they had amassed it, they had potentially mailed one at a time, and that showed really aggravated, terrible conduct. I'm not saying as a baseline it's not terrible, it's all terrible. But what we're doing is we're differentiating among defendants. So in a world in which the mail is used for the purpose of distribution, it really matters whether the person has distributed 1 or 5 or 1,000. And so the guideline says, you know what? We are going to treat a person who's distributed 1,000 a lot worse, because that shows that this person is really engaged in this really horrible behavior. In comes the internet. On the internet, with one click, you can receive, you can distribute tens of thousands. You can be doing this for 15 minutes, and all of a sudden, you are looking at 30, 40, 50 years in prison.
Good. Good.
I understand,
Absolutely
Senator, but
good. I hope you
what we're
are.
trying to do
Good.
Allow her to finish, please.
I hope you go to jail for 50 years if you're on the internet trolling for images of children in sexual exploitation. So you don't think that's a bad thing? I think that's a horrible
That's
thing.
not what the witness said, and she should be allowed to answer this question once and for all.
Senator, all I'm trying to explain is that our sentencing system, the system that Congress has created, the system that the Sentencing Commission is the steward of, is a rational one. It's a system that is designed to help judges do justice in these terrible circumstances by eliminating unwarranted disparities, by ensuring that the most serious defendants get the longest periods of time. And when modes of commission of the crime change such that in 2 seconds, someone can receive or distribute thousands of images, that's no longer and this is what the commission found in their studies, an indicator of a person who, relative to other people, has committed this crime in a more aggravated way.
Well,
and so what we're trying to do is be rational in our dealing with some of the most horrible kinds of behavior. This is what our justice system is about. It's about judges making determinations in meting out penalties to people who have done terrible things.
It is not rational to take the venue of choice of child pornographers, the computer that have 85 million images on it, and not consider that feeding the beast. We're trying to get people to stop this crap. So when you troll on the internet and you pull down thousands of images of children from the internet, I want you to stop that. I want people to go to jail who do that because you're feeding the beast. We have a bill here, the Earn It Act, that would allow the victims who are on the internet over and over again to sue the media companies that provide these images. We have a fundamental differences of how you deter crime. I think the best way you deter crime when it comes to child pornography is you lower the bloom on anybody who goes onto the internet and pulls out these images for their pleasure.
Senator, every person in all of these charts and documents I sent to jail because I know how serious this crime is. Every person I discussed the harm of these terrible, terrible images to the victims who are portrayed in them. I talked about what this crime does to the children who are being abused in these photos, and on the other side of their terms of imprisonment, I ensured that they were facing lengthy periods of supervision and restrictions on their computer use so they could not do this sort of thing again. That's what Congress has required of judges, and that's what I did in every case.
You always were under the recommendation of the prosecutor, many times the parole people. And to be honest with you, Judge, a 32-year-old man who sent an image of his own 10-year-old daughter, you substantially reduced the not only the guidelines, but the recommendation. And all I can say is that your view of how to deter child pornography is not my view. I think you're doing it wrong, and every judge who does what you're doing is making it easier for the children to be exploited. If you're on a computer right now looking at a kid in a sexually compromising situation and you get caught, I hope nobody gives you a break because you used the computer.
The conduct that's been described is reprehensible, and I think everyone in this room agrees. And the fact of the matter is that I'm co-sponsor of your bill, the Earn It Act, and I believe that we should be doing our job here. But part of our job, we have failed in responding to the changing circumstances that face this crime. What has it been, 15 or 16 years? She is currently not an outlier in sentencing. 70% of the federal judges face the same dilemma and wonder why Congress has failed to act and when it